Practice before the IRS is broader than most people think. It's not just showing up to an audit. It includes communicating with the IRS, representing someone at meetings, preparing and filing documents, and even giving written advice that could lead to tax avoidance or evasion. On the EA exam, they'll test whether an action counts as practice, because that determines who's allowed to do it. Limited practice is the big exception. Some non-practitioners can represent a taxpayer because of a relationship, even if they didn't prepare the return. Start with the easy ones. You can always represent yourself. Immediate family can represent immediate family, and certain business roles can represent the entity. A bona fide corporate officer, a general partner for the partnership, and a regular full-time employee for their employer. The family rule is narrow, and that's where exam traps live. Immediate family generally means spouse, child, parent, brother, or sister. Notice what's missing: uncles, aunts, cousins, in-laws, and fiancés. If they're not in the immediate family list, they don't get automatic limited practice just because they're related. You'd need another basis, like being a fiduciary or getting special authorization. Fiduciary status is different from being a representative. A fiduciary, like a trustee, executor, administrator, receiver, or guardian, is treated as the taxpayer for that estate or trust. That's why a fiduciary can deal with the IRS at every level for that entity. On the EA exam, if you see executor of the estate or trustee, think not just POA power, fiduciary authority. There's also a rare escape hatch, a special appearance. If someone isn't otherwise eligible to practice, the IRS commissioner, or a delegate, can authorize them for a specific matter. The request goes through the Office of Professional Responsibility, OPR, and if it's granted, it's written and limited to the circumstances approved. Translation for the exam: it's possible, but it's not automatic, and it's narrow. Finally, know who can't practice. Entities like corporations and partnerships can't practice before the IRS. Only individuals can. And even an individual won't be recognized if they've lost eligibility, suspended, disbarred, placed in inactive retirement status, or they failed enrollment renewal requirements like continuing education. Key exam point: a Form 2848 doesn't fix ineligibility. The IRS just won't recognize it. Which of the following is not automatically allowed to represent a taxpayer before the IRS due to a special relationship? An uncle representing his niece, an officer representing a corporation, a regular full-time employee representing an employer, or a general partner representing the partnership. Think about which relationship is outside the IRS automatic list. The correct answer is the uncle representing his niece. Limited practice for family is limited to immediate family, spouse, child, parent, brother, or sister. The tempting wrong choice is the employee, because people assume any employee can call the IRS, but the rule is a regular full-time employee representing their employer, which is allowed. If an enrolled agent is disbarred from practice, what will the IRS do? Will it allow limited practice rights for past clients, refuse to recognize a power of attorney naming the individual, allow occasional tax shelter advice, or allow representation before the examination division? Think about what disbarment does to eligibility. The correct answer is that the IRS will not recognize a power of attorney naming that individual as a representative. Disbarment means the person is no longer eligible to practice before the IRS, so a Form 2848 doesn't help. A tempting wrong answer is letting them represent past clients, but the IRS doesn't grandfather representation rights after disbarment.